double agents, government agencies, and a determined plaintiff who decided to be his own lawyer. Stay tuned to find out how a case went off the rails faster than a runaway truck. Hi, I'm Leela from Courtroom 5, and this is Who Wrote That Up for You, where we explore stories about people navigating civil court without lawyers. Today, we'll take a look at the case of Harris versus the U.S. Department of Transportation, a case that proves even the best laid plans can go awry. Abram J. Harris thought he could take on the U.S. Department of Transportation, but it turns out they had a few tricks up their sleeves. Let's see how Harris ended up with more legal questions than answers. Abram Harris, the owner of a commercial trucking company, hired a woman who was simultaneously employed by the Federal Motor Carrier Safety Administration, FMCSA, an agency within the U.S. Department of Transportation, DOT. Get that? She was moonlighting for a federal agency that oversaw trucking companies like Harris's. When Harris's working relationship with his new employee went south, his connection with the federal agency did the same. Harris thought these two incidents were related. To him, the woman weaponized her position at the DOT to retaliate against him. It was essentially making his life difficult as a trucking company owner. So, in May 2022, Harris filed a lawsuit against the DOT in D.C. Superior Court, alleging fraud, abuse of process, and statutory violations. Convinced that the agency's lawyer had defamed him online, Harris even named that lawyer as a defendant. Harris filed the case pro se. That's a Latin term meaning for oneself, which is just a fancy way of saying he represented himself in court. Imagine navigating a foreign city with no map, no GPS, just your own instincts. That's what going pro se is like. You're charting your own legal path, relying on your own skills and knowledge, but the chances of taking a wrong turn or getting completely lost are much higher. Courtroom 5 can guide you through the complexities of legal procedures and argument. It empowers individuals to interpret the law, apply it to their specific situation, and present their cases effectively. Think of it like a GPS for the legal system, helping you understand where you are, where you need to go, and how to get there. Back to the Harris case. Fast forward 2 months. The court noticed that Harris hadn't served the DOT. That means he hadn't properly given them the lawsuit papers. Based on this, the court dismissed his case without even waiting for a response from the DOT. Harris appealed the decision to the D.C. Court of Appeals a mere 3 days later. But the DOT had something waiting for him. It pulled a move that even seasoned lawyers might not see coming. It snatched the case from the D.C. Court of Appeals and deposited it squarely in federal court. While plaintiffs choose where to file their lawsuit, defendants can remove the case if federal jurisdiction existed from the start. Removal allows defendants to transfer certain cases from state court to federal court when the case involves a federal question, when the parties are from different states and the amount in controversy exceeds $75,000, or when the defendant is a federal agency or officer. In this case, the DOT removed the lawsuit because, as a federal agency, it had the right to be heard in federal court. Harris, on the other hand, thought that once his case was dismissed in state court, it couldn't just magically appear in federal court. But the court said, not so fast. They clarified that as long as the case was still pending in the state system, the DOT could remove it to federal court. Now, let's talk about where Harris stumbled. He didn't object to the removal of his case or ask to go back to state court. By not doing so, he lost his chance to fight the removal. Also, Harris didn't challenge the district court's reasons for dismissing his case. He didn't raise any arguments about why the dismissal was wrong in his appeal. So, the court essentially said, sorry, you forfeited your chance to argue that. The federal court ultimately dismissed Harris's case for 2 main reasons. First, they cited lack of jurisdiction, which is legal speak for you're in the wrong courthouse. The second reason was failure to state a claim. In normal human language, this means Harris's allegations weren't enough to support fraud and abuse of process. That is, even if they could hear his case, Harris didn't present a solid enough argument for it to proceed. Here are some key takeaways from this case. 1. Launch objections early and often. Harris's experience is a classic reminder. If you're going to object to something in court, make sure to do it early and often. Harris didn't raise objections about the removal of his case until it was too late, leading to a forfeiture of his chance to argue about it later. This mirrors a key rule in litigation. If you see a problem with your case, speak up quickly or you risk losing your ability to complain. It's like noticing your roommate has rearranged all your furniture while you were at work. If you say nothing for 3 months, you can't suddenly sue him cause you stubbed your toe on that awkwardly placed coffee table. In court, the rules are strict. Raise objections immediately when issues arise or forfeit your right to challenge them. 2. Properly serve defendants. It's a must. In Harris's case, one of the key reasons behind the district court's dismissal was that he failed to properly serve the defendants. Instead of correctly filing papers with the U.S. Attorney's Office as required, Harris mistakenly attempted to serve the D.C. Attorney General. This blunder was pivotal. It's like inviting someone to a party who wasn't even in the birthday girl's social circle. So, if you want your case to move forward smoothly, understand the rules and procedures of serving defendants. Otherwise, your time and effort may end up in the legal equivalent of the trash bin. 3. Suing your opponent's lawyer is a costly mistake. Suing the opposing party's lawyer is almost always a bad idea. It's a common misstep that can derail a case before it even gets going. One major reason is litigation privilege, a legal doctrine that protects attorneys from being sued for statements made in the course of legal proceedings. This means that even if a lawyer says something false or damaging in court filings or arguments, they're generally immune from defamation or related claims. Courts take this privilege seriously because it allows attorneys to advocate zealously without constant fear of personal lawsuits. Beyond that, suing the other side's lawyer can make a judge question your motives. It often looks like retaliation or an attempt to intimidate. This can damage your credibility. Worse, it can distract from your actual claims, turning your case into a procedural mess. Instead of suing the opposing lawyer, a better strategy is to challenge their conduct through motions, bar complaints, if truly warranted, or simply by strengthening your case against the actual party responsible. Had Harris spent more time strengthening his case, he may have avoided dismissal for failure to state a claim. How would you have handled this situation? Add your comments below. This has been Who Wrote That Up For You? Goodbye until next time.